result of their military service, and for civil rights and opportunities that maximize the independence of PVA members. More information about Paralyzed Veterans of America, its programs, and its initiatives can be found at pva.org. And next slide. Disability advocates often say that the demographic of people with disabilities is one that anyone can join anytime, anywhere. According to the American Community Survey, over 5.5 million veterans have joined this august community, with over 3 million of those having become a person with a disability through military service. Of that latter number, almost 600,000 have acquired significant disabilities in service to Uncle Sam. Next slide. Although comprehensive statistics are difficult to compile, government data shows 42,000 veterans with spinal cord injury registered with the VA healthcare system. Another 16,000 veterans with multiple sclerosis have entered the system, as well as over 156,000 legally blind veterans, and another 1.1 million veterans with visual impairments. From the most recent conflicts in Iraq and Afghanistan, and this is according to data from the U.S. Army Surgeon General's office, among the combat wounded from all military services are over 1,500 patients with major limb amputations. This includes 486 wounded troops with multiple amputations. Over 2,500 servicemen and women have suffered traumatic burns. Over 5,000 have received severe blast eye injuries. 336,000 have suffered documented hearing loss. Over 250,000 servicemen and women have suffered traumatic brain injury, including 3,949 with penetrating head wounds, and over 44,000 have received severe or moderate brain injuries. In the Army alone, over 73,000 soldiers have been diagnosed with post-traumatic stress disorder as a result of their combat experience. Next slide. Under the Fair Housing Act, veterans with disabilities are covered as people with disabilities. Veteran status and military status are not protected classes under the Act. There may, however, be some states that have adopted ordinances protecting them, but for purposes of federal law, veterans would be covered under the broader protected classes of race, sex, national origin, religion, family status, or disability. For many of these veterans, the two most important aspects of the Fair Housing Act are its accessibility guidelines and the Act's reasonable modification and accommodation requirements. These provisions make it unlawful for someone to refuse to permit reasonable modifications of existing premises if such modifications are necessary to afford a person with a disability full enjoyment of the premises of a dwelling. The next presenter will go into a bit more detail on these aspects of the Fair Housing Act, but I just introduced that for your information. And the next slide. The benefits of assistive animals for people with disabilities have long been recognized. We typically think of guide dogs or hearing dogs that are trained to perform tasks such as carrying notes and alerting their owners to oncoming traffic or other environmental hazards. Veterans with disabilities such as PTSD or traumatic brain injury can also benefit significantly from assistive animals by providing therapeutic nurture and support. The law generally requires the landlord or building management to make an exception to a no pet policy so that a tenant with a disability can fully use and enjoy that dwelling with the assistive animal. Next slide. Although single-family homes are not covered by the Fair Housing Act's accessibility guidelines, Veterans with disabilities seeking to buy or rent such a home would benefit from many of the other protections of the law. These include prohibitions against refusals to rent or sell housing, refusals to negotiate for housing, making housing unavailable, setting different terms, conditions, or privileges for sale or rental of a dwelling, providing different housing services or facilities, falsely denying that housing is available for inspection, sale, or rental, or denying access to or membership in a facility or service related to the sale or rental of housing. Next slide. Some years ago, PVA asked its chapters for feedback on housing problems that its members typically face. In rural areas, especially places without a building code, there are ongoing concerns about multifamily properties being built that are not accessible but are supposed to be. Affordability of accessible housing is another big problem for PVA members and many veterans with disabilities. If someone has a disability and receives housing assistance, it's difficult to almost impossible to find a rental unit which meets their voucher requirements and is accessible and sanitary. PVA's service officers have had some success helping veterans in asking for reasonable accommodations to increase the voucher amount, but locating housing in an appropriate price range is still difficult. Newer housing is more likely to be accessible, but it is costlier. A few years ago, the General Accountability Office released a report that estimated there were some 2.3 million veteran renter households with low incomes. Over half of those, about 1.3 million, had rental costs exceeding 30% of household income, which is HUD's definition of housing affordability problems. Of the 41 largest public housing authorities contacted by GAO in that study, 14 were found to offer a veteran's preference in their administration of public housing. That's not really a housing problem, but more just an FYI for our listeners' purposes. Next slide. The Department of Veterans Affairs has three main grant programs to help veterans with disabilities with necessary home modifications. These are the rather confusingly named Specially Adapted Housing Grant Program, the Special Housing Adaptation Grant Program, and the Home Improvement and Structural Alterations Grants Program. The amounts of assistance vary, and only veterans with service-connected disabilities qualify for the first two grants. The Specially Adapted Housing Grant is available to veterans who have a service-connected disability that requires them to use braces, crutches, canes, or a wheelchair. This grant is very often used to create a wheelchair-accessible home. Special housing adaptation grants are generally used to help veterans with mobility issues due to blindness or the loss of the use of both hands or certain severe burn injuries. Under the Home Improvements and Structural Alterations, or HISA program, veterans with service-connected disabilities or non-service-connected disabilities may receive assistance for home improvements necessary for their continuation of medical treatment or for disability access to ensuring that their home has essential lavatory and sanitary facilities. There's something called the Temporary Residence Adaptation Grant Program that allows veterans or seriously injured active duty service members who are temporarily residing in a home owned by a family member to receive some funds under the adaptive housing grant programs to modify that home of the family member. And next slide. This slide gives you some websites from the VA with information about those adaptive housing grant programs. The smaller HISA grant is administered locally out of a VA medical center's prosthetics and sensory aids program. To obtain information about the HISA grant or any of these VA housing benefits, I would encourage people to contact a veteran service organization and ask to speak to one of their service officers. And I conclude with the next slide to say thank you for your kind attention, and that is my contact information, and would be happy to answer any questions at the end of the presentation. Thank you again.
Thanks so much, Susan. That was a fantastic overview of the intersections between disability rights and veteran status. So now we're going to dive into a little bit more detail with Morgan Williams, who's General Counsel with the National Fair Housing Alliance. So Morgan is General Counsel here at NAFA, where he supports the investigation and enforcement of cases against large banks, developers, insurance companies, federal agencies, servicing contractors, and others involved in providing, financing, and or building housing in a discriminatory manner. Previously, Morgan was General Counsel at the Greater New Orleans Fair Housing Action Center in New Orleans, Louisiana. Morgan graduated with a BA in Environmental Studies at Oberlin College and with a JD magna cum laude from Tulane Law School. He has served on the adjunct faculty at American Law School and Loyola Law School of New Orleans. Morgan is a past recipient of the Equal Justice Works Fellowship, the Effective Leadership Fellowship from the Terry Sanford Institute of Public Policy at Duke University, and the Rockefeller Foundation Redevelopment Fellowship from the Center for Urban Redevelopment Excellence at the University of Pennsylvania. With that, I want to kick it over to Morgan.
Thanks so much, Kevin. I was wondering if you could just briefly give an overview again, as you did at the start of the presentation, on how folks can submit questions. We'll of course be taking questions, Susan and I, at the end of our remarks. But Kevin, if you could just let folks know how they can go ahead and submit questions in the meantime at any point, or of course raise them at the end.
Sure, absolutely. So if you have a question at any point throughout the presentation, please feel free to go ahead and type out that question for us in the questions section of the GoToWebinar toolbar. So you'll see there's a toolbar on the right-hand corner of your screen. It'll have a number of options, including a chat function and then a questions function. So all you have to do is go ahead and type your question in that question section, go ahead and hit enter, and then when it comes to the Q&A session at the end of the presentation, we'll read it aloud. So definitely feel free, if anything comes to mind, to type us a question.
Thanks so much, Kevin. And of course, we'll be addressing questions at the end. In the meantime, I did want to note that Rachel Dean, NAFA's Associate Director of Enforcement, is also online fielding questions online. So if you submit a question electronically, she, who is an expert on these matters, is also going to be helping to field questions directly. Of course, we can't answer specific case questions, but we can answer questions about the law and background information on all of this material. Thanks so much, everyone, for joining us this afternoon. This is really an exciting assembly of folks really participating in this webinar, coast to coast, including fair housing advocates, of course, as well as veterans advocates, disability rights advocates, housing industry folks, folks from HUD and municipal governments, and really a broad cross-section of folks. And it's great to be coming together in this space, and we appreciate this opportunity. And one of the things that we are always trying to do at the National Fair Housing Alliance is work as a movement and with our members to broaden our partnerships. And we're particularly excited to be working more closely with folks in the veterans rights community, as well as always in the disability rights community, and of course housing industry folks and on our HUD and municipal government partners. We really do want to continue to build those partnerships, and we see this webinar as an opportunity to work to forward those efforts. You can go to the next slide there. So I'm going to start off by giving just a brief background on the National Fair Housing Alliance, and then jump into the nitty-gritty of disability rights in the housing market. So we're going to start with a kind of threshold question of who is eligible for reasonable accommodation and modifications, and really what is the definition of disability under the Fair Housing Act. And then we're going to just outline kind of the rules of the road. As Susan sort of teed up in talking about some of the general rights that are out there, we're going to delve into specifically talking about the 3 affirmative rights for people with disabilities under the Fair Housing Act. There's really a lot that could be said, and we have a limited amount of time, and so we're going to focus on reasonable accommodations, reasonable modifications, and design and construction requirements. We're going to define all of that and talk about how that applies in some different contexts. The next slide there, Kevin. And we are going to, in the course of doing that, really hit some of the nitty-gritty issues that Susan and some of her colleagues in the veterans' rights communities flagged, including homeowners and condo associations, and applying some of these rights in that context. The verification requirements and certification issues that can come up when dealing with accommodation modifications, especially in light of some of the recent guidance associated with the Americans with Disabilities Act and how it contrasts somewhat with folks' rights in the housing context. And talk specifically about federally assisted housing and common accommodation requests in this context, as well as paying for modifications and how that differs in different parts of the housing market, and in particular in federally assisted housing. And then talk about some more resources that are out there for folks to delve into these issues more deeply. Go to the next slide there. So the National Fair Housing Alliance works to eliminate housing discrimination and ensure equal housing opportunity for all people through leadership, education, outreach, member services, public policy initiatives, advocacy, and enforcement. And of course, for all people is underlined there. The Fair Housing Act really has a dual purpose, and that is to eliminate housing discrimination and to promote more integrated living patterns. And that's something that really, across protected classes and across communities, we all have deep interest in. Next slide, please. The National Fair Housing Alliance was established in 1988. It's headquartered in Washington, D.C. It is a national civil rights organization and works in partnership with some other fantastic national civil rights organizations, forwarding issues at the national level across a broad array of fair housing contexts in partnership with HUD and Department of Justice and the CFPB and other federal partners. We are a nonprofit organization, although some of our work is HUD funded, including some of the costs associated with this webinar training. We have a national membership of organizations and individuals, but specifically we work to support some of our operating members, which are local fair housing offices in different communities. And I would really encourage folks on the call who are not, who don't have existing relationships with the fair housing offices in their communities to reach out to those offices and please engage us as we are working across communities and jurisdictions across the country to reach out to folks, in particular in the veterans' rights world and veterans themselves. And we'll talk more at the end of the presentation about how you can link up with some of those offices. We at the National Fair Housing Alliance engage in a number of efforts, including education activities, this webinar among them, enforcement work, which is actually the arena in which I work, assisting our enforcement staff in conducting investigations across various sectors of the housing market: rental, sales, insurance, lending, REO, and others, design and construction, and then bringing cases against entities that are liable for discriminatory conduct that we identify in the course of our investigation. In addition to education enforcement work, NAFA also provides consulting services for large industry housing providers, and we also do research as well as member services and a number of other activities. Next slide. So we're here today to talk about veterans' rights and housing discrimination. Military status, as Susan mentioned, is not protected under the Federal Fair Housing Act. There are, of course, 7 federally protected classes, and race, color, religion, national origin, sex, familial status, and last but not least, disability. We are working at the federal level to expand protections under the Federal Fair Housing Act. There are efforts to expand protections for veterans, for protections for people on the basis of sexual orientation and gender identity, as well as sources of income, which is also an issue that many veterans have an interest in, as there are specific veteran voucher programs. There are, however, local and state statutes which have protections that extend beyond the Federal Fair Housing Act, and we have here listed some of them: Illinois, Massachusetts, New York, Ohio, Washington. This is a list that was prepared by NAFA's policy director, Jorge Soto, who is working on some of the federal advocacy issues. And if there's folks on the webinar who are forwarding some of these legislative efforts locally or nationally and are interested in collaborating with us, he's a great resource. And he did identify these states where there are state statutes that protect against discrimination on the basis of military status, which includes veterans. However, because it's not protected as a matter of course under the federal law and in many jurisdictions across the country, we will look to other protections that may come to bear on the veteran community. And as Susan mentioned, with roughly 5.5 million veterans with disabilities across the country, there are a lot of fair housing rights that directly impact the veteran community. Next slide. And part of what we're talking about here is really a civil right, and it's something that we at NAFA feel strongly about, and really as a country we feel strongly, and it's something that fair housing advocates are certainly interested in forwarding. And here we have a public service announcement. Ty served his country and fought for freedom. Shouldn't he be free to choose where he lives? And we have here information on pursuing a HUD administrative complaint if you feel that you've been discriminated against. And we'll talk more about those resources at the end of the remarks here. Next slide. And as Susan mentioned, there are a variety of disabilities that veterans experience, and the figures are hard to come by, but those that Susan put forward included a long list of different types of disabilities. And here, for example, she noted that over 300,000 veterans have suffered documented hearing loss. And we put forward a PSA here just with one of our colleagues who is deaf and who we've worked with in the past in carrying out investigations, who is in this public service announcement, just to sort of illustrate, that really when we're talking about disability, we're talking about the very specific experiences that veterans are dealing with day to day, and discrimination that they may face in the housing market. And you can go down that list that Susan put forward, and that's exactly the issues that we're interested in confronting. And that's exactly the set of issues under the Fair Housing Act that people have rights to confront. And we're interested in working with everyone on this webinar to further those rights. Next slide, please. So the laws that we're going to talk about, briefly today are threefold. Largely the Federal Fair Housing Act, and that's the focus of a lot of the rights and responsibilities that we're going to detail and unpack a bit in the next few minutes. It was a law that was passed in 1968, a week after the assassination of Dr. Martin Luther King Jr. It was the federal congressional response to the assassination and the unrest that followed. It was signed into law by Lyndon B. Johnson, and it was put forward as a strong piece of civil rights law, as I said, to really put an end to discrimination in the housing market and give people rights to enforce acts of discrimination in the housing market, and also to promote more integrated communities, noting that we as a country at the time lived in a very segregated society, and as it is to this day, continue to live in very segregated communities. And so there is much work to be done under this law. There is the Section 504 of the Rehabilitation Act of 1973 details additional similar rights to people with disabilities. It's a law that covers, again, federally assisted housing, and we're going to talk more about it in particular in instances where we're talking about rights that may extend beyond the Fair Housing Act. Much of the rights that are detailed for people with disabilities under Section 504 dovetail with the Fair Housing Act, and we're going to talk a little bit about where some of those rights extend further for tenants and housing consumers. And the third law that we'll talk some about is the Americans with Disabilities Act. There's a lot that could be said about the Americans with Disabilities Act and rights for veterans and people with veterans with disabilities. But we're going to talk briefly about a couple of components of the law that come into play in certain aspects of the housing market and that relate in different ways to rights that tenants and housing consumers have under the Federal Fair Housing Act. Next slide, please. And so talking about the Federal Fair Housing Act, it was passed in 1968 prohibiting discrimination on the basis of race, color, religion, and national origin. It was amended in the 70s amidst the women's rights movement to add the protected class of sex and prohibit gender discrimination. And then it was amended again in 1988 to add the protected classes of familial status, which, whether or not you have children, and disability. And when the Act was amended in 1988 to add the protected class of disability, the House Judiciary Committee noted that the Act repudiates the use of stereotypes and ignorance and mandates that persons with handicaps be considered as individuals. The committee went on to note generalized perceptions about disabilities and unfounded speculations about threats to safety are specifically rejected as grounds to justify exclusion. And so Congress, in amending the Act to add people with disabilities to prohibit discrimination against people with disabilities in the housing market, had a keen sense of the stereotypes and the exclusion that people with disabilities face in our country. And these rights are meant to promote more inclusive living for people with disabilities. Next slide, please. So there's a threshold question before we get into the sort of nitty-gritty of some of those affirmative rights. Who qualifies as a person with a disability? And before I get into the definition, I want to just note that the fair housing disability definition is really different than the qualifications for Social Security or other government programs. And I put these two figures forward just to sort of help illustrate that. There's 8.8 million people that receive disabilities Social Security assistance in the United States. It's a rough estimate. The number of people with disabilities is also hard to quantify, and it's likely a low number, but one estimate put forward 48.9 million people in the United States with disabilities. And so when we're talking about disabilities, we're really talking about a broad definition that extends beyond what a lot of government programs look to in specifically defining disability. We're talking about a definition under the Federal Fair Housing Act that actually parallels the definitions under the other two laws that we're looking at, Section 504 of the Rehabilitation Act and the Americans with Disabilities Act. Next slide, please. And the definition there is specifically a physical or mental impairment which substantially limits one or more major life activities. Having a record of such an impairment or being regarded as having such an impairment. And so we're talking about physical impairments, which could be, various loss of limb that may preclude activities such as walking or engaging in, other household activities. It could be mental impairment, which, could be something PTSD or other types of mental impairments, emotional distress impairment. And it could be having a record of having such an impairment, notably alcoholism and recovery from other substance abuse issues is regarded as having a disability, as having an impairment, a record of having that impairment. And we'll talk a little bit more about that, but that is prior. That is someone who is not a current user of illegal controlled substances. but somebody who's recovering from such an addiction, or being regarded as having such an impairment. It could just be a perception of having that impairment and then being treated in a discriminatory fashion, or not afforded certain affirmative rights. And that could be someone with HIV who may not actually have any conditions specifically that impair major life activity, but that they may be treated as having such a condition. Next slide, please. And when we're talking about this definition of disability as a sort of threshold question here, there's a couple of specific exceptions. As I noted, current use of illegal controlled substances, conviction for illegal manufacture or distribution of a controlled substance, or the direct threat to the health or safety of others. And we're going to talk a little bit more about the direct threat exception to what constitutes a disability, or what establishes an exception to the requirement, to the affirmative duty to grant a reasonable accommodation request or modification request. I'll talk a little bit more about that. But in addressing this threshold question, we can go to the next slide about what defines a disability. We want to also just talk a little bit about sort of discrimination based on disability. And the first thing that we want to say is, as Susan noted, the sort of basic treating someone differently as this language outlines in the housing market on the basis of disability is regarded as discriminatory under the Fair Housing Act, just as treating someone differently on the basis of race or sex or national origin would similarly be regarded as discriminatory. This slide sort of indicates, in very clear terms as it's detailed in the statute, if you're treated differently based on your disability in buying or renting a home, or intending to reside in a dwelling, or really in the housing market broadly, as it's detailed in the language of the statute, that would constitute discrimination based on disability. Next slide. And in the context of that, it's illegal to ask about the nature or severity of a disability. You can ask specifically questions related to eligibility, if having a disability is a requirement of program eligibility, when disability is necessary for a preference or priority, such as that accessible units are set aside for people with disabilities, whether you can ask, as we noted in the course of the definition of exceptions to disabilities, whether a person has been convicted of distribution or manufacture of controlled substance, or is current illegal user of controlled substance. Next slide. And so basically, under this definition of disability, a physical and mental impairment that substantially limits one or more major life activity, there is this principle under the Fair Housing Act that says you can't discriminate on the basis of disability. And basically that means, in effect, you can't treat someone differently because of their disability as they engage in transactions in the housing market. However, the 1988 amendments went further than adding disability as a protected class under the Fair Housing Act. They went further in detailing 3 really important affirmative rights that people with disabilities have in the housing market. And in this way, in some senses, on the basis of someone's disability and need to engage in an integrated fashion in the housing market, there's an affirmative duty that housing providers have to actually treat someone differently because of their disability. So this gets a little bit complicated for housing providers. So on the one hand, are thinking to themselves, well, we've really got to not treat people differently on the basis of their disability because that would be discriminatory. On the other hand, there are these affirmative rights where they actually have an obligation to treat someone differently on the basis of their disability in order for them to enjoy the housing and live in an integrated fashion in the housing market. And so it's sort of this contrast that gets a little bit tricky for housing providers. And I hope that by specifically talking about the 3 affirmative rights that people with disabilities have, it can become clear sort of how those 2 obligations or responsibilities in the housing market can coexist. And so we're going to outline these in turn briefly and really try to get into the detail of each, and then allow for some questions at the end. And the first that we'll talk about is reasonable accommodation. And reasonable accommodations are changes in rules, policies, practices, or procedures of housing providers to allow a person with a disability to fully enjoy a dwelling. Next slide, please. And here we have another PSA that we've prepared in partnership with HUD. And here it details someone with a service animal, an assistance animal of some sort, and that is really a common example when thinking about a reasonable accommodation request. Just to give one example, and we're going to go into a lot of other specific examples to help to show what a reasonable accommodation request is, and a change in a policy to allow someone with a disability to be able to use or enjoy a housing. The service animal example is good because it clearly includes a clear policy, and the policy is no pets. And that is a policy that some housing providers practice, and there's nothing wrong with precluding pets. However, a reasonable accommodation is occasionally necessary for people with disabilities that use assistance animals to be able to live in housing, and if there's a no pet policy, then it excludes them from that housing. And so reasonable accommodation request is to request change in that policy to allow a tenant with a disability to be able to use a service animal. And if that's a request that's forwarded on the basis of the need for the service animal for the individual with the disability, then the housing provider has an affirmative duty to provide that accommodation request. And that's the gist of a reasonable accommodation. Next slide. So what we have is a person who has a disability within the meaning of the law, as we've just talked about, a substantial limitation, physical or mental, to a major life activity. An accommodation, a change in a policy, is needed for the person to benefit from the housing, and the housing provider knows or should have known of the nature of the disability and of the need for the accommodation. Next slide. And if that is what has taken place, then the housing provider, again, has this affirmative duty. They have an obligation to make the changes to the policies, rules, practices, or services to accommodate the disability, which affords equal opportunity to the tenant to use and enjoy the dwelling, including public and common use areas. Again, an area in housing that's covered by the Fair Housing Act, as well as the Americans with Disabilities Act. We'll talk a little bit more about that. Next slide. Window accommodations have to be made. Again, this is an affirmative duty, and it's a change in a policy. And so, as a housing provider that's working to administer uniformity among your policies, it's important for you to understand when you actually have to change those policies, and you have an obligation to do so. And accommodations have to be made when the reasonable accommodation request is, when the accommodation request is regarded as reasonable. And we'll talk more about what that means. As a lawyer, we often operate in the territory that exists in the ambiguity of some of these words, like reasonable. And we'll talk a little bit more about what it means, but it is very fact-specific, as reasonable accommodation requests are. And there must be a connection between the requested accommodation and the disability, or the need for the change in the policy. There must be a nexus, as it said, between the disability and the requested change. And if that's the case, then the requested accommodation must be acted upon, and it must be acted upon in a reasonable time, because a delay may amount to a constructive denial of the accommodation. And that's a violation of the Fair Housing Act. That's a civil rights violation. And so it's important that housing providers understand the reach of the need to respond to these accommodations, and then also that they must be responded to in a timely fashion. Next slide, please. When is an accommodation unreasonable? A request for an accommodation, it said, may be rejected if it's unreasonable. And there's really two contexts in which a request may be regarded as unreasonable. One is if it would pose an undue financial and administrative hardship. And the other is if it would fundamentally alter the nature of the program or the housing providing that's being offered. So let's just give a couple of examples for both of those so that it can be understood. Because again, a lot of this is very fact-specific, and we're going to delve into some examples in a minute. The accommodation would pose an undue financial and administrative hardship. Let's say the accommodation was to provide a lower rent for the unit, and there's not other extenuating circumstances except that the person with a disability is on a fixed income, that's SDI, and unable to pay the rent. That would be something that would be regarded as a financial or administrative hardship. Fundamentally altering the nature of the program. Let's say there's someone with a disability who has difficulty doing their own laundry, and there, maybe even is a machine on site in a common use area. The request may be to have the housing provider assist with the laundry services of the tenant. That would be something that would really be beyond the nature of the program that the housing provider was engaged in, because they are really there to provide housing. And providing laundry services is a separate kind of program, and it would fundamentally alter the nature of the program. And that would be regarded as unreasonable. Next slide. So in talking about a reasonable accommodation request and the fact that, if a request is made and it's on the basis of someone with a disability who's got a specific need that's associated with that request, then there's affirmative duty. There's a question about what verification the tenant must provide in establishing to the housing provider that there's the need for this accommodation. Because once that's established, then the housing provider has to grant it if it's reasonable. And the housing provider may request reliable disability-related information that's necessary to establish that there's a qualified disability, describe the need for the accommodation, and show that the accommodation the disability and the need for the accommodation are related to one another, that the accommodation is really a change in a policy to satisfy or allow someone with a disability to really use the housing in a way that they wouldn't with the policy in place. The verification can be provided from a really broad array of folks that have knowledge of the disability and the need for the accommodation. Could be a physician or psychologist or some trained social worker or other mental health professional. It could be a peer support group. It could be non-medical service agency or a reliable third party in a position to know about the disability. And this is like, practically speaking, this is a letter that someone in this position would write that would detail that there is a disability that requires this accommodation. It can be very succinct and to the point. There are some sample documents that will reference in some resources at the end of the presentation that folks can look to in establishing or securing these verification documents. But the housing provider can request these verification documents in order to establish that there is a need for the accommodation. Next slide, please. However, in establishing the disability and the need for the accommodation, it's really not a question of diagnosing the disability. Unlike program eligibility, it's not the name of the disability that matters or the source of the income. It's how the disability of whatever type affects a person's ability to go about daily activities. And so that there is some disability that limits their daily activity is all that needs to be established in that verification letter, not the specifics of the disability. And labeling, the disability is not necessary, and the disability itself does not normally have to be disclosed. Next slide. And furthermore, if the disability is, which referred to this slide as invisible or not obvious, then there may be the need for the verification. However, if it's obvious, then the verification that establishes the disability is not required. There may still be need for some verification that establishes the need for the accommodation, but the need to establish the disability, if it's an obvious disability immediately apparent to the housing provider, doesn't need to be verified. If the landlord is skeptical of a tenant's alleged disability, then it's the duty of the landlord to request that documentation or open up a dialogue. basically what's going on in the course of the process of forwarding a reasonable accommodation request is that it's an exchange. And it's an exchange between a housing consumer and a housing provider. And there's an obligation for sharing of information back and forth. Next slide, please. One of the things that we wanted to note in regards to reasonable accommodations is that we're talking about changes in policies, and so oftentimes it could occur without any added cost to the housing provider. But in some instances, there may be some expenses. Let's say that the accommodation is a set-aside parking space, handicap parking space, in proximity to a tenant's unit. There may be some expenses associated with the signage or striping of the asphalt for the accommodation, and that would be an effect of a change in policy, and that would be something that the landlord or the housing provider would have to bear the cost of, even in the private market. In any context, a reasonable accommodation, a change in a policy is something that the landlord has to bear the costs of. Next slide, please. If the accommodation is denied, the housing provider, that's not the end of the discussion. There really is kind of a back and forth here. The housing provider has a duty to engage in what's this interactive process. And the duty is to really consider whether there's some alternative obligation that could meet the tenant's needs. If it's a function of, laundry services, allowing some third party access to the complex, in order to do the laundry for the tenant, and granting an accommodation of the access of this third party to the common facility may be an accommodation if there's some policies that would preclude that. In the context of someone who is requesting that the housing provider provide laundry services, and that would be an unreasonable request because it would perhaps alter the nature of the program that they were providing. If there was a denial in that context, the housing provider would have to have an affirmative obligation to engage in this interactive process. And on this slide, there's a reference to the HUD-DOJ joint statement on reasonable accommodations here. At the end of the presentation, we're going to be referencing some valuable HUD, DOJ, and other organization documents that provide significant additional background information on these topics. And this is a cite to the frequently asked question 7 in the HUD-DOJ joint statement on reasonable accommodations that sort of delves into this further. Next slide. So the response to the accommodation may not be conditioned. So the housing provider can't then charge a fee for allowing someone with a service animal to have a pet when there is a no pet policy, or requiring something extra like insurance for the accommodation. Next slide. The exception to this affirmative duty that the housing provider has when reasonable accommodations are forwarded is the direct threat rule. And this is in an instance where an individual with a disability poses a direct threat to the health or safety of other tenants or to the damage of the property. This individual is not protected under the reasonable accommodation modification provisions of the Fair Housing Act. And here, if the request is to, allow a tenant with a disability to, perhaps, waive some policy associated with a live-in care attendant who would be in the subsidized housing program. Maybe a voucher holder would be eligible for a live-in aid and a 2-bedroom unit associated with that. And they're in a housing complex that allows them to have that unit. If there's some disability where, as a result of a mental disability, they still pose a direct threat to the safety of other tenants. In that instance, it may be grounds for not granting the accommodation. However, there's an exception to this exception, which is that if the individual who may at some point have shown some behavior that would have indicated that they pose a direct threat receives some intervening treatment or medication that eliminates that direct threat, then the housing provider must still grant the accommodation. And one other point I want to make about direct threat, the direct threat rule, is that it really requires a circumstance in which there's a specific occurrence that objectively gives rise to an assessment that the individual poses a direct threat. It can't be some sort of hypothetical speculation associated with someone's general condition. It has to be some specific occurrence that would give rise to the direct threat. Next slide, please. Typical reasonable accommodations include designating a handicap parking space, allowing someone with a service assistance or companion animal when there's a no pet policy, transferring to a ground floor unit, allowing a tenant who may develop a mobility impairment in the course of their tenancy to move from a third floor unit, for example, down to a ground floor unit where they may have a more easy time entering and exiting the unit. Perhaps late rent payments because disability income arrives, at the middle of the month rather than at the first of the month, and it's suitable for the person with a disability to be able to pay their rent at that time period. Next slide, please. There's a couple of points that we want to make here about assistance animals under the Fair Housing Act, and we make this in part because a lot of the reasonable accommodation request disputes that do come up oftentimes deal with assistance animals, and there has been some recent guidance that Department of Justice and HUD have issued in regards to assistance animals under the Fair Housing Act. An assistance animal is not a pet, rather it's an animal that provides assistance or performs tasks for the benefit of a person with a disability. And an assistance animal under the Fair Housing Act does not need to be trained or certified. This is different than in the context of the Americans with Disabilities Act in a sort of public services context, where you may be talking about an assistance animal at an airport or some other public space. In the housing context, an assistance animal specifically does not need to be trained or have certification if they are providing some therapeutic value. While dogs are the most common types of assistance animals, in the housing context, other animals can be assistance animals. A horse that may provide some physical therapy to someone may be an assistance animal, or a pig that may provide emotional support. This is, of course, different than recent guidance by the Department of Justice under the Americans with Disabilities Act for service animals in public spaces. We're talking about assistance animals in the housing context under the Fair Housing Act, and really we can talk about, again, any variety of animal that may provide some therapeutic value. Next slide, please. And so when can assistance animals be denied? Well, it should be noted that the breed, the size, or weight limitations may not be applied to assistance animals. So the breed of an animal in itself is not a basis for denying an animal. If there's a specific animal that poses a direct threat to the health or safety of others or would cause physical damage under the direct threat exception, that could be a basis for denying an assistance animal, but not any animal that just on itself is denied because of its breed or its size or its weight. It must be a specific assessment made to the individual animal. Next slide, please. So there's a couple of reasonable accommodations that we want to just outline briefly in talking about federally assisted housing. And a part of this is on the basis of a memo that the National Housing Law Project put out, which I'll reference in the resources portion of the presentation. So if there's more interest in this topic, please, I would recommend checking out some of the resources that are cited in the material here. But one example of an accommodation may be in regards to credit history. A person with a disability may have a negative credit history as a result of his or her disability and request an accommodation to ignore the credit history. Again, you know, if someone with some significant disability develops some medical expenses that for whatever reason out of their control, that you know, insurance was disputing for some period of time or whatnot, caused some credit issues, those were then resolved, then the tenant could put forward an accommodation request to say, you know, I know it's your policy to look at credit in admission to a program, but in this case I would request an accommodation. Criminal background, similarly, may be something that a housing provider may look at in admission to a housing program. And if someone with a mental disability can show that you know, their vagrancy charges were a function of a period of time in which they were suffering from a disability that they have since received treatment for and is under control, then they may, again, ask that specific crimes that can be associated with the direct result of their disability could be put forward as something that should be overlooked despite a criminal background policy. And that would be a reasonable accommodation request that could be forwarded. Next slide, please. And so what we're going to do is actually breeze through some of the rest of this presentation, because I do want to give some opportunity to questions at the end. And there's still a decent amount of material to cover, although we'll cover a lion's share of what we want to tackle here. Some additional examples of reasonable accommodation could be an extension of time in a voucher program to search for housing using a voucher, or portability, which could allow someone with a voucher to transfer it to another jurisdiction when there may be some policies that would limit or restrict that transfer. Next slide. In the occupancy of a unit, again, if someone with a disability may request a larger unit because they have a live-in aid, or they may request early termination of a lease because they have to move jurisdictions in order to receive some medical treatment, or there may be some other nexus with their disability that will require such an early termination. Next slide. Typical violations of reasonable accommodation requests include outright denial of a request for an accommodation, unreasonable delay, as we said, is a constructive denial, conditioning an accommodation by charging a fee, such as a transfer fee or pet deposit, conditioning an accommodation by requiring some action before it is granted, requesting medical documentation of a form that is sort of beyond when the disability is obvious, failing to engage in the interactive process when denying an accommodation, or some combination of the above. Next slide, please. So what we're talking about when we're talking about reasonable accommodations are that the requested accommodation must be made if it's reasonable, if there's a connection with the disability, must be responded to in a reasonable amount of time, and the housing provider bears the cost of the accommodation. Next slide. So the second bucket of affirmative rights that people have are reasonable modifications. And reasonable modifications, next slide, are like reasonable accommodations, except instead of changes to policies, we're talking about physical changes to units, structural changes that afford the enjoyment of the dwelling, adding a flashing light for a doorbell or a phone, removing the lower cabinets in a kitchen or bath, building a ramp, raising a wall, adding a sunroom, these physical changes. Next slide. And they have the same basic rules as reasonable accommodations under the Fair Housing Act. We're talking about the same definition of disability. We're talking about the same rules about verification regarding the disability or the need for the modification. And we're talking about the same delay in approval that may amount to a denial of a modification or a physical change. Next slide. The owner has some right in approving modifications. They can ensure that the work be done in a workmanlike manner, and they may require that the renter restore any interior modifications to their prior state after the tenant leaves the unit. And they may require that some deposit for the restoration is put aside into escrow. Next slide. However, the housing provider can't put other conditions on the type of construction or the color or the contractor or even the plan for the modification. If they do want a more expensive modification, then it's incumbent upon them to pay for the modification. Next slide. However, the tenant is required to provide upkeep on the modification, and the housing provider is in a common use area required to provide upkeep of the modification. Next slide. So one thing that we wanted to flag here is who's responsible for paying for a reasonable modification. Again, this is a physical change to a unit. The housing provider has an affirmative duty to allow for this change to be made. But unlike an accommodation, the housing provider under the Fair Housing Act actually doesn't, in the private market, have a duty to pay for the modification. It's the tenant that has to pay for the modification, then has to pay to change it back if that's what the housing provider prefers, if it's in the interior of the unit. However, in the public housing context or in housing that receives federal financial assistance under Section 504 of the Rehabilitation Act, the housing provider is actually obligated to pay for the modification in instances where there is a physical change that's requested to a unit in order to accommodate a disability. So a tenant who uses a wheelchair and lives in a privately owned house who needs a roll-in shower in order to bathe independently is required to pay for that change. However, that same request is required in housing that receives federal financial assistance, then the housing provider is required to pay for that roll-in shower. Next slide. So just in recapping accommodations and modifications, adding a ramp at the front door of an apartment, that's a physical change. That's a modification. Tenant's required to pay. Providing grab bars in a newly constructed apartment building. That is likely a modification because it's a physical change. There may be instances in which it is a design requirement, as we'll talk about shortly. Providing sign language interpreter to discuss an eviction. That's a service, a policy, and a practice, and that would be an accommodation. Meeting a disabled applicant or an applicant with a disability at an accessible location because your office is not accessible. That may be a separate ADA violation or issue, but that practice or that change is an accommodation. Widening a bathroom door in an apartment, again, modification. Communicating in writing during an application inquiry with a deaf applicant, accommodation. Changing your usual policies to permit service or assistance animal, of course, accommodation. Next slide. So who must comply with the accommodation and modification request? Really, it applies broadly. It applies to property owners, managers, homeowners and condo associations, lenders, even state and local governments, often in the land use context. There's a specific memo that applies to group homes and land use reasonable accommodation requests that the Department of Justice and HUD have issued. But I wanted to note here specifically that homeowners and condominium associations are required, just as landlords and other housing providers, to allow accommodations and modifications on properties within their associations. And you may hear homeowners associations say, well, we have bylaws that prohibit this kind of physical change. That is not sufficient to overcome the Fair Housing Act. The Fair Housing Act would trump those bylaws. There's case law that supports that, and it's sort of the functional equivalent of a landlord putting forward a lease that would say, we have this contractual agreement that would preclude some sort of pet policy. That is superseded by the Federal Fair Housing Act, and there's case law to that effect. Next slide. And so the third and final bucket that we briefly wanted to touch on here is the design and construction context. Next slide. And this is the third set of affirmative rights for people with disabilities, which simply applies to new multifamily housing. says it must be built in an accessible manner. Just as the Americans with Disabilities Act sets out certain design and construction standards for new construction in the public accommodation context, the Fair Housing Act and the amendments to the Fair Housing Act in 1988, as its affirmative rights that people with disabilities have, this affirmative duty that developers and architects that are building new multifamily housing have to do so, meeting certain threshold accessibility requirements. Next slide. And just as in the context of a reasonable accommodation or modification, the threshold question is sort of what constitutes a disability. Here, the question is what are covered units? And it's multifamily properties with 4 or more units built since March 1991, and it's basically all of the units that are on accessible floors. So if it's an elevator building, it's all of the units must meet these standards. If there's no elevator, then it's all of the ground units must meet these standards. And it does not, specifically does not include townhouses. Next slide. And so the new construction standards that we're talking about are 7-fold, talking about accessible public and common use areas, which are also covered under the Americans with Disabilities Act, accessible doors, routes through the property, light switch, and other environmental controls that are reachable, reinforced walls in the bathroom, not that there are grab bars installed, but that the walls are reinforced in order to be able to install the grab bars. Usable kitchens and bathrooms so that there's sufficient clear floor space to navigate those spaces. Next slide. What's wrong with this picture? You've got a parking spot with a access aisle. However, there's no curb cut. There's no means for a wheelchair user to transition from their vehicle to the sidewalk without having to go into traffic. Next slide. And here, you've got a kitchen with very limited floor space, such that someone who had mobility impairments would have difficulty navigating, accessing the stovetop and the sink and entering and exit that door there. So that would be an example of a kitchen that doesn't have sufficient clear floor space. Next slide. And so these design and construction requirements come into play when paying for modification, because if the changes are needed by the tenant that should have been included in the design and construction criteria when the unit was constructed, then the housing provider may be responsible for paying for those changes. But if they're not a function of the design requirements and it's not a covered unit, then it may be regarded as a modification and the tenant would be regarded for paying for it, again, unless it's housing that receives federal assistance. Next slide. So here we have a couple of examples. A tenant with a disability resides in a ground floor apartment, non-elevator building that was built in 1995 and requests doors wide enough to pass through with her wheelchair. Here, a likely issue covered under the design and construction requirements, and there may be liability that the housing provider has to actually pay for or make these changes. A tenant with a disability resides in an apartment with a building that was built in 1987 and requests doors wide enough to pass through with her wheelchair. This unit was built before the law was changed, and so, isn't a covered unit under the design and construction requirements, but the tenant herself would still have an affirmative right to the modification to make that change. And here we have a tenant with a disability residing in an apartment with a building that was built in 1993 and requests to install grab bars in the bathroom because of her disability. And here, this is, again, an example of a unit that would likely be covered, but that is a modification that is a design feature of the design and construction requirements, and so it will be regarded as a modification. Next slide. And so very briefly, I wanted to underscore that violations of affirmative rights for people with disabilities do constitute housing discrimination. In January, the Oregon Attorney General reached a settlement with a housing provider following a request for an accessible parking spot closer to a couple's unit because the limited ability to walk to their vehicle. Shortly after the request was made, the individual who forwarded the request fell in the parking lot, sustained injuries that resulted in complications, and they passed away. And this is a settlement that resulted from the denial of that civil rights request, and is emblematic not only of the extent to which there's significant liability associated with these requests, but also the extent to which these requests are really about people with disabilities being able to access housing in a safe and integrated fashion. The Department of Justice engages in rigorous enforcement of this issue, and you can go to this link to actually see their case summaries. And if you do just a search, Control-Find search for the words accommodation, modification, or design construction, will produce many dozens of cases that the Department of Justice has brought against large and small housing providers across the country that have violated individuals' rights in regards to these affirmative duties. Next slide, please. I want to briefly touch on a few of the resources that are available for folks that want to get into this information. Thank you. I know this presentation will be made available to folks, so you can go back and access these links. There's the HUD-DOJ joint statements on reasonable accommodations and modifications, which are set up in a Q&A fashion and really will address a lot of the issues that folks may have in thinking through how these very fact-specific standards play out in different parts of the housing market. HUD issued a memo in April of 2013 on service animals and assistance animals that provides clarity, in particular following the Department of Justice's clarification under the Americans with Disabilities Act about what is required of service animals. And the HUD memo details specifically what is required of assistance animals and other service animals in the housing context. And Fair Housing Accessibility First, which is administered by HUD, is the go-to place on the internet to learn more about the design and construction requirements under the Fair Housing Act. Next slide, please. The Bazelon Center for Mental Health Law has fair housing fact sheets that include a great deal of helpful information in thinking through some of the different scenarios in which someone may be forwarding specific reasonable accommodation requests, and there's also attached to those fact sheets very helpful sample verification and request letters, and those documents can be accessed from the Bazelon Center's website at that link. Next slide, please. And there's a lot of resources that are available for folks that are living in federally assisted housing and are forwarding reasonable accommodation or modification requests. There's additional information that HUD provides on Section 504 requirements of federally assisted housing providers. The National Housing Law Project has a very helpful memo on reasonable accommodations in federally assisted housing, which informed a part of some of the examples that we put forward on that topic. And the Bazelon Center has a report entitled Increasing the Usability of Housing Choice Vouchers for People with Disabilities, which is a helpful resource. And the last resource slide that I just wanted to note is in instances where there are parties that have experienced violations under their rights under the Fair Housing Act, there's some resources that are available to complainants. One is please take a look at NAFA's website. The Find Local Help tab brings up a map of the country, and you can click on different communities where there are NAFA member organizations. It can be a great resource in providing assistance when you have a complaint or further training on different questions that you may have about material that was covered. And then if you do feel that you've been aggrieved under the Fair Housing Act, in addition to filing a lawsuit, HUD also administers a complaint process, which was added to the Act in 1988 as well. And individual aggrieved parties can file housing discrimination complaints with HUD, and then it's incumbent upon HUD to carry out an investigation to assess whether there was discrimination and try to broker some resolution. Next slide. And I wanted to close before we jump back in with Susan to field any questions that folks might have, to note that civil rights are hard fought, and the rise of disability rights and civil rights generally have really developed in the United States with the recognition of the sacrifices of our military veterans. And that continues today. The Disability Independence Group blog has a post from this month about Florida's new service animal statute, and really outlines some of the history of the relationship between disability rights and civil rights, and the recognition of the important service that our military veterans provided to our country. And it's something that, from fair housing organizations' perspective, we sincerely appreciate, and we look forward to continue to build off of our partnerships in forwarding additional civil rights for people with disabilities and veterans across the country.
Great, thanks so much, Morgan. So this brings us to our Q&A session of the webinar. So we want to open it up for some questions here. Again, a number of people have already asked questions through the questions function of the toolbar, but if you do have questions, please go ahead and type your question in there, and we will try to get to it in this last 10 minutes that we have in the presentation. So again, if we don't get to your question today during the webinar, please feel free to contact one of us at the National Fair Housing Alliance or the Paralyzed Veterans of America. So with that said, I'm going to go ahead and read off a few questions here that we have from folks who've submitted already. So the first question we have is in regards to how a service animal is verified and whether or not the animal needs to be licensed according to local rules and ordinances that the city might impose. So, our management company is allowed to require a tenant with a service animal to sign a pet agreement to follow all of their established rules. And what are some issues that might arise between having a service animal that might conflict with local ordinances about animal policies within departments?
Thanks so much. Susan, I'm happy to take a crack at that unless there's any initial thoughts that you wanted to respond to.
No, go right ahead.
Great. Well, this is actually specifically one of the issues that Susan flagged as we were preparing for the presentation that we wanted to cover. And so, I think I've hit some components of this, but I appreciate the question because it is something that we want to ensure that we clearly address. And so I will, just note in brief, in response to the question, under the Federal Fair Housing Act in Section 504, so in the housing context, there is not the need to have an assistance animal be licensed. There's simply, in order for them to be granted an accommodation, there's simply the need that they would provide some therapeutic value. This is different than under the Americans with Disabilities Act, where a service animal specifically needs to be certified. And Kevin, if you could scroll back to the first resources slide, the HUD resources. The third memo there, the HUD memo on service animals and assistance animals, is specifically going to address your questions about the licensing requirements of service animals and assistance animals. But one thing I want to make clear is that under the Federal Fair Housing Act, in the housing context, assistance animals do not need to be licensed. Under reasonable accommodations, a reasonable accommodation specifically cannot be conditioned on some other requirement. One example of a condition would be if someone's requesting a waiver of a no pet policy and the housing provider says, I'm going to charge you a pet fee. That would be a condition, even in the context of a housing provider who might have a policy that allows for pets but charges a pet fee. That pet fee would be regarded as a condition and a violation of the Federal Fair Housing Act. Similarly, if the housing provider grants an accommodation but requires the tenant to sign up to some pet agreement, an additional condition on the accommodation, that would constitute a violation because it would constitute a condition on the accommodation. There's a third part in addition to the licensing and pet agreement component to the question, which I believe dealt with service animal requests and instances which that may somehow contradict municipal or other code. Well, all of these requests are very fact specific. However, the if there is some code that somehow bars some animal, then it may be the situation that there's actually a reasonable accommodation request that the municipality may have to make in some instances to allow for accommodations. And I wouldn't think that the housing provider, beyond instances which the animal poses a direct threat, or in instances where somehow the requested accommodation is regarded as unreasonable in that it poses some undue financial or administrative burden to the housing provider or fundamentally alters the nature of their program, that request could be denied even in instances in which there may be some municipal code that would challenge some components of making the request.
Okay, thanks for that, Morgan. We have another question about the prevalence of discrimination in the rental and ownership market when it comes to disability. So Joshua Case just is essentially asking, where can we find some statistics about the prevalence of discrimination in these markets against veterans and also against people with disabilities?
Well, I'll take a stab briefly at talking about it sort of broadly in the housing market, and Susan, maybe you can speak to some of the issues specific with information about veterans. In regards to the housing market generally and discrimination against people with disabilities, NAFA publishes an annual trends report, which we release every April, and which we recently released a 2015 edition of. And that document, in addition to looking at sort of current enforcement trends in the fair housing movement, assembles data on the private complaints that were filed, as well as the HUD and Department of Justice enforcement actions that were taken. And it documents the number of complaints on the basis of different protected classes. And in recent years, disability has been the most prominent or protected class, together with race and familial status, on which there have been fair housing complaints. And you can go to our website to locate our trends reports to get information on that data.
All I was thinking as I was listening to the question, there was a GAO report some years ago, I think it was 2007, that looked at the rental market for low-income veterans. That's the closest thing I can think of that might have some information there about discrimination lodged against veterans in the rental housing market.
It could also be, if someone's interested in researching this issue, one thing that they could do is go to those states that do have those local protections and assess the extent to which there have been complaints or enforcement brought in regards to those protections. That may be a place to begin to do some research on the extent of discrimination on the basis of military status or veteran status.
Great, thank you both so much. So we have a question here that might be particularly suited to Susan. The question is, how can we raise awareness of these federal protections among the veteran community?
Well, that is a good question, because so often issues that affect veterans as people with disabilities, they don't cross in. That connection is not made by veteran service organizations. I guess my thoughts are what PVA always encourages disability advocates to do is to reach out to the broad range of veteran service organizations, Disabled American Veterans, American Legion, Veterans of Foreign Wars, AMVET, Iraq, Afghanistan Veterans of America. Many of those organizations have local chapters, and if there are fair housing advocates in a community who are interested in veterans with fair housing issues affecting veterans with disabilities, then reaching out to their local veteran service organizations and their local chapters would certainly be one way of partnering. A lot of states have, they go by various names, veteran councils, committees that are organized at the state level, touching base with the Department of Veterans Affairs regional office. There are regional offices throughout the country, and they would probably know of local veterans groups in those regions that fair housing advocates could connect with for these purposes.
Great. Thanks so much for that answer. So it looks like we've hit 3:30, but we do have quite a few questions here. So maybe we can just read maybe one or two more questions, and if folks have specific concerns, we can definitely assist you via email after the presentation. So we did have a question from Daryl Ford about drug and alcohol addiction, and so Daryl asks, does drug or alcohol addiction ever qualify as a form of disability, and sort of how is that assessed from a fair housing context?
The answer is yes, absolutely. Addiction and recovery from addiction is regarded as a disability, and there's been research that would show that the condition of having that addiction and recovery from that addiction constitutes an impairment to a major life activity in various ways. And there's extensive case law that establishes that someone who is in recovery from substance abuse or alcoholism constitutes a person with a disability, and they are able to forward reasonable accommodation requests in order to accommodate their disability. One instance in which there are common reasonable accommodation requests that are forwarded on behalf of service providers that actually service people with addictions are group homes, or homes that are community settings to support individuals in their recovery from addiction. Those homes may experience discrimination from communities that don't want those facilities in their neighborhoods, and they may engage in discriminatory conduct to block the creation of those homes or close down those homes. And there's been an extensive case law brought by Oxford House and other group home companies across the country to challenge discriminatory practices and to forward reasonable accommodation requests in the land use context. However, there are a number of other case examples of individuals who afford reasonable accommodation requests for changes in rules or policies to allow them to be able to enjoy dwelling on the basis of their disability of recovering from substance abuse.
Great, thank you. So we have one last question that I'll announce here, and it essentially goes to the point of what you do about discrimination when you encounter it. So for people on the line, we talked a little bit at the end of the presentation about how to file a complaint, but could you just talk about if people experience discrimination, if they have clients who are experiencing discrimination, how we can help them to file a complaint?
Absolutely, and if you could just go to that resource page for folks. If folks are themselves experiencing discrimination or working with clients or colleagues that experience discrimination, one strong primary resource that we would flag for folks is local fair housing centers in your communities, and to contact those offices. Those offices engage in investigations and provide advocacy work for individuals that are experiencing discrimination in enforcing their rights under the Federal Fair Housing Act. Many offices will assist individuals in preparing reasonable accommodation requests and assembling the proper verifications and really shepherding certain individuals through that request process, which can be an intimidating thing in some instances when communicating with the housing provider in that context. And so reaching out to local offices, if you go to the National Fair Housing Alliance website there and click on the Find Local Help page, then it'll bring up a map of the country, and you can click on your jurisdiction and see which member organizations are located there that can provide help to individuals that experience discrimination. And of course, always available to anyone that's experienced discrimination is the ability to file a HUD administrative complaint process. You can do that online, over the phone, or in writing, there's a link there for the HUD portal for filing a discrimination complaint.
Okay, great. So I just want to let folks know that they are able to, again, ask questions directly to the panelists via email after the presentation. We appreciate everyone who participated today in the Fair Housing for Veterans and Service Members. Thank you to Morgan and Susan for both lending so much insight into this important issue. So we'll also be distributing a PDF of all of the slides so that you can access the resources and sort of review all of the materials and information we discussed today. Also, we're going to be uploading the entire presentation to YouTube, so you're able to go on YouTube and watch if you'd like to take another look. So thank you all so much for joining us today, and have a great day.
Thank you very much.
Thank you.